where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And they're like, well, I guess we can't do any business with you, obviously. It's not good for our bank to be seen as doing business with somebody who's being prosecuted by the government. These people are the worst.
You're allowed to predict, for example, that you'll get your rent restrictions lifted, or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartoff said is that appraisal could be sitting on your desk, and you don't have to rely on it.
Leticia James, Leticia, had a rough day in court today. She's fighting to keep her $450+ million judgment on the books after it came out from the judge Arthur Engoron, aka the Nip, Areola Engoron, and his law clerk. They enabled the Attorney General of New York to go after a private business and judge their contracts for loans with banks. If you remember this case, we had Alina Abba in court. Tish James was taking her shoes off, stinking up the whole building. Arthur Engoron was moving the cameras around the courtroom so nobody could see his game of footsie with his law clerk, passing notes to each other endlessly. Well, what they did is they civilly, essentially criminalized Trump to the tune of $450 million by saying that his loan deals were bad, even though the banks never claimed they were victimized, never complained about it at all. Every single one of his statement of disclosures, financial disclosures, says, do your own vetting on my assessment of my net worth. And they did until Tish came in, that this was ever even a thing in New York. So I want to show you what happens here. We are in the appellate division in New York State. We have these 5 judges here on the panel. We're going to pay close attention to this gentleman. As this woman here comes up to the podium, you'll see this is the government's attorney from Tish's office. And the way this works in appellate proceedings is often the person presenting will give a bit of an opening statement. We've heard this here when we've covered Supreme Court oral arguments. They come in, may it please the court. My name is Robert Gouveia. Your honors, we're here today to discuss this issue about how corrupt the FBI and the DOJ are and why they should be disbanded because of their constitutional violations. And today our main argument is the following. And you give a little bit of a speech and you say thank you, right? Maybe it's a minute, 2 minutes, sometimes it's longer, but the judges will usually cut you off, right? You'll hear Clarence Thomas come in. Mr. Gouveia, is it true? Of course. Yes, your honor, it is. You're true. A boy can dream, right? But it is common to be interrupted in your oral arguments. But watch this one, okay? This one came fast. This woman didn't even finish her name, and this judge seems like he had a little bit of extra pep in his question. Let's listen.
You have 10 minutes on this.
Well, I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that
Okay.
I think that maybe simplifies things. May it please the court, Judith Vale for the New York Attorney General's office. All of the defendants repeatedly violated...
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners, where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence?
Wow.
Where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
Several responses.
And I want to add to his question.
So that was just a devastating takedown. If you heard all of that, that judge had that question in his mind and he just eviscerated her. He said, hello, these are co-equal parties, okay? This is not like some sophisticated person, unsophisticated. These are like national, international banks that Trump was dealing with. $100 million entity with $1 billion entity. Trump had disclosures. They were on even playing fields. There was no undue pressure. No one even complained about it. They did multiple business deals. Have you ever done this before at all, ever in New York? And don't tell me about your cases, by the way. I read your briefing. It's not what happened in those cases. And this other judge is jumping in too. She's like, yeah, and I want to add something to that. It's brutal, okay? She didn't even get the last syllable of her name out.
And little to no impact impact on the public marketplace.
No one even got
Well,
hurt.
maybe I'll take that first, Your Honor, and work backwards. There was absolutely a public impact and a
What?
public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here.
There was no deceptive risks. The banks did their due diligence. Trump did his due diligence, and they came to terms. They made
But
money.
it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record. And you have to remember something. As the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower. And then you do the stress test and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated. That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr. Haig
collateral.
testify that there were 14 factors and this was the least important factor?
Well, certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors that are being considered.
So when the bank is doing their assessment on how to assess risk and their interest rates, the things that Trump was talking about didn't even matter to them. She's like, well, but it could have or should have.
For materiality, it's whether it's important to the overall total mix of information. And this was absolutely critical to the overall mix of information, not only because they were looking specifically at what the net worth was in order to decide the terms of the loan, in order to figure out whether they would take on this risk, but also the financial statements were coming in each year and they were important, critical to the loans each year because Deutsche Bank was reassessing the risk every single year. And it was using...
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
Well, to go back to the first question about whether...
Yes, in other words, if Deutsche Bank was upset about this, if Deutsche Bank feels like they got screwed, oh, Trump lied to us. His building was 1,000 feet smaller than he said it was. Like, that's what they're arguing about. No, your property was a little bit smaller, or 2% smaller, or something like that. And so you fibbed your numbers. So if Deutsche Bank feels like they got screwed, they come back and say, hey, Trump took advantage of us, broke the contract, made a bunch of money. Sue him, because he signs that his disclosures are true and accurate right here in my statements. Sue him for a breach of contract in commercial litigation. Why didn't you do that? Why didn't you leave it up to the parties to rectify this? Why did Tish James have to campaign on doing this in order to get elected and then do it? Is that justice?
There's other examples of this. There are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very
We've
big
done
bank,
this before.
Wells Fargo,
We have precedent.
and a professional appraisal firm.
Wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing?
And that concern is here as well, because when you have hidden risks getting injected into the market, that hurts the market and honest participants in the market. And the legislature also decided, contrary to what defendants think, that making sure that business in New York stays honest is the way to attract and keep business
So to that
in New York.
point, the Executive Law 6312, I just want to read a section of it. Well, not exactly, but was enacted to promote and protect honesty and integrity. It's the same question I asked the other side. In commercial marketplaces in New York, by stopping fraudulent and illegal businesses. To accomplish this purpose, the statute authorizes the Attorney General to bring civil enforcement proceedings on behalf of the people whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transacting of business. I don't read harm or threat of harm in that, but the other side is saying that that is to be read into the statute. Are there any cases where the language harm or threat to harm limits the scope of the Attorney General?
No, Your Honor, not as to liability, and not in cases like this. What the Attorney General is seeking is injunctive relief and disgorgement. Greenberg for the New York Court of
So her power is broad, very, very broad. It doesn't give her any power to go investigate any entity. There has to be a harm from that entity in order to give her jurisdiction to initiate a claim. Here, the judge is saying, I don't see harm in the statute, so it's not even in there. So can she do whatever she wants, basically?
Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here. And remember to think about the illegality claims as well, because it's not just fraud. For the illegality claims, you look to the underlying penal law provisions. And for something like issuing false financial statements, there's no requirement for reliance. There's intent and there's materiality, which was proved at trial. But if someone issues a false financial statement to their counterparty, the counterparty gets it and is not fooled, picks up the phone and calls the enforcement authorities, the crime has still been committed, even though the counterparty didn't rely on it at all.
You're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford.
Okay, so just compare and contrast those two cases. She's saying, okay, you're saying that this action against Trump is valid because it's very like these other cases. What other cases? The Lehman Brothers, which collapsed due to massive fraud. Or this other guy who was a real estate evaluator who is very sophisticated, defrauding people. Like it's part of the business. Trump was building real estate properties and renovating properties as part of a business deal.
Hardly seems that justifies bringing an action to protect against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money. And that was the point of my initial question.
Shout out to
Every
this
case
judge.
that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
Well, first of all, Your Honor, the statute doesn't require that whatsoever for liability. And the statute is written broadly because the legislature wants the Attorney General to go in and stop fraud and illegality.
Counsel,
whether
an
it-
example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes, and the
it didn't affect the
investors-
public, at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that was
Yes.
not meant to do? And that's something you must address because there has to be some limitation on what the Attorney General can do
No,
in
it's Tish.
interfering in these private transactions, as Friedman said, that where people don't claim harm. So what is the limiting principle?
Well, I'll say two things,
Don't
Your
be
Honor.
Trump. That's
well, first
it.
of all, the limiting principle
Don't be
are
Trump.
what's in the law. So the illegality claims require intent. They require materiality.
Let's talk
most
about the
of them.
but talk about the standalone.
Just for the 6312 fraud. Well, this court has defined that rather broadly, but there are still limits. It is not falsity in the wind, first of all. It is not falsity that you whisper to someone on the couch. It has to be related and relevant to the business at hand, and it does have to have a capacity or tendency to deceive. And I will stress, Your Honor, that this does have harm to the public and to the markets. And I think what Your Honor is saying is that in some of the other cases, the ripple effects happen to happen. It went so far that the ripple effects from fraud went on to hurt the market. But what the legislature wanted was 6312, just like for the Martin Act. And the Court of Appeals talks about this in assured guarantee.
To be prophylactic, is that what you're about to say, counsel?
Yes, look at the assured guarantee case from the Court of Appeals. It talks about how a big point of these statutes, not the only point, but a big point is for the Attorney General to go in quickly to stop the fraud and illegality before it gets to the point that counterparties are harmed or it
Tish
has
has
those kinds of
total
ripple effects in
control.
the market. I do want to, though, push back on the idea that Deutsche Bank never complained and wasn't harmed at all. Deutsche Bank did complain. When they first found out about the alleged misstatements and omissions, they raised serious concerns with defendants, said that misstatements in the financial statements would be an event of default. They asked for more information, and when they didn't get more information, they exited the entire relationship with the Trumps. That shows that they cared about the financial statements being truthful and accurate.
What
and
year
that
was
they
that
were.
in?
It was right when they first heard about the allegations, so I believe it was 2020, Your Honor.
Oh, after
Although
you
I'd have to check
filed?
the precise year on that.
After you
and
filed.
Mazars as well. When Mazars found out
I was going to say, that never came in at trial, okay? And we didn't hear that about the relationship evaporating. So they start prosecuting Trump for fraud, saying he defrauded Deutsche Bank. They're like, well, I guess we can't do any business with you, obviously. It's not good for our bank to be seen as doing business with somebody who's being prosecuted by the government. These people are the worst. It's like you illegally prosecute somebody. You say, wow, that guy's he's a rapist and he's got a bunch of PDF files on his hard drive and all the things. The whole society then shreds that guy. Turns out he didn't do anything wrong at all. And you're like, well, society hates him. So see, we're right. Like, you didn't do it. You corrupt prosecutor losers. This is how the government works. It's sick.
About the alleged misstatements and omissions, they also sent a letter saying these financial statements should not
And the judge called her out on that. What year was that? Okay.
be relied upon anymore. So it is not true that the counterparties didn't care or never complained, even though that's not required for 6312.
Back to Justice Moulton's point about line drawing, because I do think that that is very important in this case. You know the history of this statute. It's passed under then AG Javits and then was really amplified by AG Lefkowitz over the years. And when I went back and read the bill jackets, the AG needs greater powers as the people's lawyer to protect consumers, civil rights, and the environment. And so again, with that sort of historical backdrop to this law, how do we draw a line or at least put up some guardrails to know when the AG is operating well within her admittedly broad sphere of 6312 and when she is going into an area that wasn't intended for her jurisdiction?
Sure, Your Honor. Well, I will say, although there was certainly concern about consumers, especially at the outset of 6312, in some of the legislative history, there were multiple bills being passed, and some of them were more specifically consumer protection statutes, which I think explains some of the focus. And the legislature wrote this statute. It doesn't say consumers in it. It wasn't focused. I mean, of course, we want to protect consumers. I'm not
And
not
it
saying
does
otherwise.
start off with the words to protect honesty and integrity in the commercial marketplace.
So whatever she wants.
Yes, Your Honor. And
Very
it also
broad.
is it says
That
quite
judge is
broadly,
not gonna be on our
whenever
side.
whenever any person engages in fraud or illegality, that is meant to include businesses large or small.
Dictator
because
Tish
this
runs
kind
New
of
York.
deceptive risk does cause problems for the honest business people who don't do it this way and don't get the ill-gotten gains. And it does inject risks into the market. I mean, Your Honor, there was probably a time when most of us didn't know what a repo 105 was, which is what brought down Lehman, or what a RMBS was. And maybe, in an ideal world, the Attorney General or somebody else would have gone in and stopped that fraud and illegality when it was still just among the sophisticated counterparties and before it had the enormous harms and ripple effects that it ended up having.
Let me just ask you mentioned about the ripple effect, going on. If the threat of harm or whatever the ripple effect is so remote, does the conduct fall still? I mean, how remote does it have to be? It's the same question.
Can you do whatever you want, anywhere, for whatever
for
purpose?
the AG to follow through?
I mean, I think the remoteness
Or
problem
until
is,
it's outside of the scope of the statute as intended.
I mean, I think at least for 6312 fraud standing alone,
It's discretionary.
I think the limit does come in through the capacity or tendency to deceive requirement. I don't think that the legislature wanted to have this kind of evaluation about the precise harm out of a specific
Yeah, it's
transaction. I mean,
discretionary.
that's why harm is an issue that might be for
Yeah.
restitution, but that's
It's
not
for
an
Tish
issue
to
here.
decide.
But there is a limit, and it comes from the tendency or capacity to deceive standard that this court has put on.
Capacity
that does
to deceive?
incorporate a materiality-like standard. I think when we say materiality is not required, we're talking about the reasonable investor. That materiality is not required. It's just which objective person
There
you're
is no
looking
limit.
to. There's still an objective
She has to
standard.
stick to that.
So
That's her
there
argument.
are
That's a good point. And so which objective person are we looking to here, given that it is the nature of the transaction
Tish!
that it is? I don't want to
Tish! Whatever Tish wants.
I mean, this court has said that the standard for 6312 fraud standing alone is the objectively reasonable, ordinary, and even unthinking person.
That's
but in this
Tish.
case, the court could use the higher standard and it would be fine. Because
No, no.
these
I notice you say the ordinary standard on page 55 of your brief. You say these deceptive strategies had a capacity or tendency to deceive because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings. And you cite General Electric.
Yeah, but they weren't ordinary business
Isn't
people.
the test here whether they were likely to mislead Deutsche Bank, Ladder Capital, or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and
international
entities in
banks.
business.
Well, if the court wants to use the standard of a objectively reasonable counterparty, sophisticated counterparty, fine. They had a capacity or tendency to deceive that sophisticated party as well, because these misstatements and omissions were about objective facts that were extremely important and that any reasonable counterparty would would want to know. Any sophisticated, reasonable counterparty would want to know that the defendants were valuing an apartment based on 20,000 square feet more than it really was, based on pretending that rent regulations on certain apartments didn't exist, based on pretending that the Mar-a-Lago restrictions didn't exist. Your Honor asked about that. The trial court was very clear that it was not
Mar-a-Lago,
coming up with a magical valuation for itself. The problem with the Mar-a-Lago valuation is similar to what happened with the rent-regulated apartments. The restrictions in the deed are there. They are an objective fact. They are very restrictive. And even defendant's own expert at summary judgment, this is at 16502 of the record,
how much time does she
agreed
have left?
that the restrictions would decrease the value of Mar-a-Lago, but defendants valued it as if those restrictions didn't exist at all.
Oh, gosh.
For the disgorgement calculations, wouldn't it have been more appropriate to calculate them by calculating the difference in valuation of the property versus the valuation provided to the banks to get the loans?
No, Your Honor. The disgorgement calculation, what we needed was the reasonable approximation. What is the reasonable approximation of what defendants' fraud gained them? And defendants' theory is that the guarantee and the financial statements each year were worth nothing. But the point of the guarantee and the financial statements each year was to get the extremely favorable interest rates. And we were not speculating about the difference in interest rates. We had the counteroffer that Deutsche Bank, their own lenders, provided them for a loan without the guarantee and the financial statements. If I could touch very briefly on the statute of limitations, Your
I
Honor.
think we have it. Did you have another question?
I have a question that's
And I'll
similar
give
to
you
Judge
time for
Rosado's,
the
actually, which is the immense penalty in this case is troubling.
Yeah,
So how do you tether
that's true.
the amount that was assessed by Supreme Court to the harm that was caused here where the
one.
parties left these transactions happy about how things went down?
Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud. This went on, and illegality. It went on for 7 years during the statute of limitations period. Another reason is because the guarantee and the financial statements each year work to get enormously favorable interest rate savings to the defendants. It was a difference of approximately 4 to 8 percentage points, obviously varied by year. That is an enormous benefit that they got from the misconduct. And it is not an excuse to say, well, our fraud was really successful, so we should get some of the money.
Was there double counting in the damages assessed for the old post office and the Ferry Point?
No, there was
deals?
not double counting, Your Honor. 2 points on this. First of all, the interest rate savings and the sale profits are separate pots of money. The defendants got the interest rate savings off the top. There's no suggestion that they invested that savings into
looks like Trump's
into
lawyer's
the OPO.
laughing right here,
They were
D. John
using
Sauer.
the loan, and so they got the interest rate off the top. That
Just
was
a
the
little bit
savings
more
that they
her,
got.
and then Trump's defense
Each
will be
year,
up.
I mean, each year within the statute of limitations, they were getting a savings by doing the fraud over and over again.
So every
and the
year,
illegality.
compound the-
And then the sale profits are separate. And the sale profits, it's not the proceeds. The proceeds of the loan of the sale were around $370 million.
It feels
The trial
like it's like
court
4-1
took
to me.
out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around 126 million in profits, was his profit. That was his profit or more. I mean, I'd happy to talk about the statute of limitations quickly, although I see that my red light is on. So,
Been on
I'll
for a
give you
while.
more time for
sure, Your Honor. On the statute of limitations, each use of a misleading statement in business and each issuance of a false financial statement is a violation of the statute. And it is helpful to look at the illegality claims. Every time someone issues a false financial statement, that is a crime, and it is no excuse under the statute of limitations to say, oh, although I issued a false statement in 2017, I should somehow, for statute of limitations purposes, be free and clear because I also issued a different false financial statement in 2011.
Is there any tension between your position and our prior decision that said we have to look to the accrual as of the date the transactions were completed?
No, Your Honor. I think the best reading of that language is that the transactions completed, the transaction is referring to the conduct that the statute is referring to, which is the fraud or illegality. So each time you issue a false financial statement, for example, that is a transaction.
I don't think it's referring to the loan.
No, Your Honor. If the court had wanted to refer to the loan completing or the loan initiating, it would have said that. And Ivanka was much differently situated. What this court said about Ivanka Trump was that she was not sufficiently involved within the statute of limitations for her with the certification, preparation, review, or use of the statements. That was why she was released from the case. Whereas the defendants that remain, each each personally were involved in the preparation and use of the statements in business. And it would really be a distortion of 6312 and this court's precedent in cases like Allen. I mean, a similar thing was happening in Allen, where the original relationship between the counterparties started before the statute of limitations, but then new fraudulent or illegal acts were happening within the statute of limitations. And what the trial court said there and what this court affirmed was the new conduct that happened within the statute of limitations is timely and actionable, but the things that happened outside of the statute of limitations are not. And I do want to emphasize that neither the trial court nor the Attorney General sought liability based on the fraud or illegality that happened in 2011 or 2012. That is not true. After this court's decision, the Attorney General was not pursuing its claims for the interest rate differential for 2011 or 2012 or 2013. We were pursuing that before, and because of this court's decision, we stopped, and the trial court appropriately separated it and said the claims that are based on fraud or illegality that happened before 2014 are out, and the ones that happened in the statute of limitations period are in. I mean, I think for the sanctions, it was not just one frivolous argument. It was multiple frivolous arguments happening, including both at summary judgment, raising the argument that disgorgement is not allowed under 6312 as a categorical matter. That is foreclosed by controlling New York Court of Appeals precedent in Greenberg, and counsel misquoted Greenberg in making that argument to make it seem as if Greenberg had not said what it said. And it was that combined with raising purely legal arguments about standing capacity to sue, raising those arguments again for the third time after the trial court had warned them and said at the motion to dismiss stage, these arguments are frivolous, but I'm not going to sanction you now, I'm warning you. And I understand the need to preserve arguments for appeal. As an appellate attorney, I understand that. But what counsel did here was not write a sentence or two and say, for the purposes of preservation, we are adding this to our brief. They wrote the whole argument again, relying on all the same cases and all the same legal arguments without explaining what, as a factual matter, was different, and that was unnecessary and frivolous.
Just pivoting to that last point, last year, the Attorney General's office was here on the continuing wrong doctrine, making the exact same arguments. This court rejected them and Trump won, and we're hearing the same arguments again, citing some of the same case law. That was sanctionable for our attorneys in the lower court, but here we are. Now, I want to point the court two citations in the summary judgment record that I think frame a lot of the questions that my colleague was asked. At 13865, there's unrebutted testimony in the summary judgment record that at least creates a disputed material fact that President Trump would have got the same deal from Deutsche Bank if his net worth had been as low as $1 billion. In their calculation, it was never below $3 billion. So it's triple the threshold. And the clear testimony is the interest rates would have been the same. He would have been on they held up a chart that would have been on the same pricing chart. So this notion that there were these 8 basis points was just not supportable. 2 to 44 of the record and in other places, the Deutsche Bank witness said, we independently assess all these valuations. We are not relying on the numbers that the client is giving us. We do our own independent assessment. That is our due diligence.
Not even
That's
what Trump
the
gave
understanding
them.
of the relevant
Don't even care.
marketplaces.
I'm sorry, sir, but so we're talking now about cause of action number 1, the fraud under 6312.
Yes, and the causation argument as to disgorgement. Yes,
Okay.
Yeah.
So we know under point taken, as to the liability on cause of action number 1, we know fraud under 6312 has a much broader meaning than common law fraud. And so there it's, as your friend pointed out, the standard is the capacity or tendency to deceive.
Which is
Did
insane.
those statements have the capacity to deceive?
Absolutely not, Your Honor, for at least 3 reasons. First of all, they're gap compliant. They're not misrepresentations. All the key things they point to is this was wrong and this was wrong. The unrebutted testimony, certainly in the summary judgment record starting at 17,916, is this is what you do in a financial statement. You are allowed to do this. You are allowed to predict, for example, that you'll get your rent restrictions lifted or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartov said is that appraisal could be sitting on your desk and you don't have to rely on it. And there's actually really powerful evidence in this case to show why that's true. Because if you look at 40 Wall Street, they said, in 2011 and 2012, the appraisals of 40 Wall Street were at 200 to 220 million, and you said 527 million. But they overlooked that a couple of years later, Cushman revised its appraisal and said it's worth 540 million, virtually matching what we had said, and they say is misleading. So it's kind of these astonishing issues. It's very similar to the valuation of Mar-a-Lago as $18 million based on a tax assessment. It's preposterous. It's a preposterous position that these factual things. So that's my first answer to that. But secondly, more importantly, we have sophisticated counterparties, as a lot of the questions pointed out. They're getting clear disclaimers. The disclaimers say what everybody already knows you do in this industry. You do your own due diligence. So how is there a capacity or tendency to deceive when you have these very clear disclaimers saying considerable judgment is required here? These values don't reflect what might be realized upon a sale and so forth.
Well, what about the Attorney General's point that may be true in this case, but we we are trying to create a fair and honest marketplace, which, will inure to the benefit of the public in the long run.
Yeah, and I would say two things in response to that. First, all the questions about line drawing. If this case falls on the other side of the line, there is no line. I mean, you heard, I think, for 15 minutes, respectfully, my colleagues struggle to articulate any clear principle that would put any transaction
No limit.
outside the reach of the statute.
Whatever Tish
on
wants,
the
she
Attorney
gets.
General's very broad and sweeping view.
Yep.
So our position is narrow, which is that on the facts of this case, all these things I've referred to, no reliance, no materiality, Deutsche Bank saying we want to give them the exact same deal, and we have clear disclaimers. Surely this is not within the statute, and if this is, there's nothing that falls outside of the statute, and that is a sweeping and unsettling thing. The second point I'd make about that is...
And I'm sorry, just to tie a ribbon around that, you mean based on the facts as they were adduced on the respective records, the summary judgment motion as to cause of action 1, the trial record as to 2 through 7. Not that the AG didn't have an interest, at least at the outset, in investigating and maybe commencing the proceeding.
We're not disputing that in this
They
opinion.
certainly have that
You're
interest.
saying once you got all the facts before the court, which
And that may have been, I wasn't on that case, but that may have been the point of our prior decision, which Mr. Isaac brought up, about this being at the pleading stage. Yes, so it was enough at the pleading stage, but at the end doesn't mean this is what should happen.
That's exactly right, Your Honor. Here we have all the facts before the court.
But the pleading in this case is like a novel. It goes on at length,
Yeah, it's from
327
Tish.
pages or something like that.
Yeah, it's from
and
Tish.
basically, those were the facts that Justice Ngoran found were proved at trial. So aren't we bound by our prior decision? I asked this question in another way before.
Very significant variations. The pleading, the complaint, cites GAP like 50 times. They said these statements are bad because they violate GAP. But you go to the summary judgment record, they have nothing. They don't put anything on GAP. The trial court never cites GAP. Our experts
GAAP is generally accepted accounting principles.
say these are GAP compliant. That's unrebutted. So there's this totally, the record looks totally different once all the facts are in.
Thank you.
Nailed it! D. John Sauer, man,
I'm
crushed.
actually going to go under my time.
Yeah,
I just
'cause-
have one observation, and I don't know, maybe I'm wrong about this, but this argument, if it doesn't show why not making a summary judgment motion was appropriate, I don't know what is. There was absolutely nothing wrong with what the attorneys did. My adversary said that she's relying on the Ernst & Young case. I read to you what you said. That's exactly what you did. One more point, and I'll sit down. Keep relying on Greenberg. This is what the Greenberg court said, Greenberg 2. Initially, we note that defendants may not raise issues on appeal that were not preserved on the record for our review. So even if they're right about what this court said and they're not right, it wouldn't matter anyway because lawyers have to preserve issues for all courts that may consider it. They have to look at things not temporally at the time, but what could happen afterward. And given that, and this isn't Brian Isaac or it's not Michael Ross, I'm reading to you from the court. They did what they were supposed to do. They did what they had to do. To sanction them is just wrong.
Thank you.
So what do you guys think about that? Woo! Man, I think they crushed. I think that Tish is in big trouble. So we're going to wait for the opinion here to drop from the Court of Appeals. Hopefully you join us as we do. Thank you so much for subscribing to our channel. Thanks for liking this video, and we'll see you back here when we get a ruling.